Thank you once again for joining us. This is a joint initiative between Bindmans, the solicitors firm, and Migrant Voice, a campaigning organisation. And you're going to hear from colleagues at Migrant Voice in a few moments. You'll also hear this afternoon from Stephen Timms, MP, who's a seasoned campaigner on TOEIC issues and not giving up anytime soon. Greg O'Cayley, who's one of the barristers working on TOEIC immigration cases and also the compensation claims that Bindmans is launching. Theo Middleton, a colleague of mine, will talk more about those compensation claims, and Julianne Morinson, who's an information law specialist barrister, is going to talk about a very special angle to the compensation claims that we are taking forward, which has to do with the way TOEIC victims' information was misused and not accurately processed by the Home Office. So let me say a little bit more about what inspired the project. What happened to people caught up in the TOEIC scandal is really nothing very novel, unfortunately. We've been here before in the UK. Stigmatization of a group that's inherently defined by nationality or race, adverse action being taken against that group en masse because of the supposed behavior of some of its members, and regardless of personal circumstances, with devastating consequences. And then that adverse mass action is followed by a slow fight for justice over many years. And these characteristics have been seen in, obviously, not only TOEIC, but also the Windrush scandal. And then some will have seen an article in The Guardian a few days ago about mass deportation of Chinese seamen who assisted in the war effort, who were deported in 1945. And only now are their descendants finding out exactly what happened to them. We're hoping for justice a bit quicker than 75 years for the TOEIC victims. And to try and secure that, what we've identified really are three ingredients to a successful fight for justice. Firstly, a campaigning strategy, and that's very important because often the only real justice comes through political action, and that needs to be prompted by a forceful and stoic campaign over some time. Secondly, collaboration between those who are campaigning, and thirdly, supporting litigation to establish legal principles about how people should be treated in future and the fact that they've been treated wrongly. And that's really the thrust of the TOEIC Justice Project, to bring those three ingredients together. And if you have a look at the website, and the address will go on the chat in just a moment, if you don't mind, Theo. If you have a look at the website, either now or later, you'll see that those three strands are really what's driving what we're up to at the moment. And what we want to do with the website in particular is put information out into the public domain that's accessible to everybody about the strategies that are happening, what's been learned so far, and what can be done going forward. We certainly, Bindmans and Migrant Voice, do not want any kind of monopoly on helping TOEIC victims seek justice, partly because we're just not resourced to be able to help everybody who's been affected, partly because there's many other organisations, solicitors firms and campaigning bodies that can contribute just as well as we can. So that's an introduction to the project. I'm now going to hand you over to Nazek, who's going to talk a little bit about Migrant Voice for the next 5 minutes, and then Stephen will talk about what's happening in Parliament. Nazek.
Yeah, thank you so much, John. Thank you. And thank you for Bindmans for organizing this event. We're delighted to partner with you on this important initiative. So I am the director of Migrant Voice, and I'll tell you a little bit about the organization and some background, and later on my colleague Cameron will tell everyone more about the campaign we run for justice for the international students affected by the English language test. So we set up 11.5 years ago Migrant Voice. We are a migrant-led organization. We're a national organization working across a number of UK regions. So our main office is based in London. We also work in the West Midlands, and we work in Scotland as well. We set up at a difficult time just before the 2010 general election, where the debate on migration was very negative and toxic, and where all political parties were, blaming migrants for everything and anything, and where migrants were presented as one of the top 3 concerns in UK alongside the financial crisis and the NHS. And of course, what this meant is people out there on the street interpreted what they heard in hostility against migrants or people who look like migrants. So, and where we set up at the time when everyone was talking about migrants except for migrants. And we felt we really needed to be part of that conversation taking place about us, without us. And it's about time we came forward and we spoke about our own issues and we told our own stories and we challenged all this, what's been thrown at us, all this unfair accusation against us that went unchallenged. So we wanted to have a voice, we want to speak for ourselves, but also because this is our home, we use the media as our main platform to speak out and also to advocate for our rights. So as well as try to address this negative coverage and engaging with journalists so they tell our stories. We also wanted to challenge injustice, using the media, our stories, our voices to challenge injustice. And this is how we came in contact with the students affected by the TOEIC scandal. They approached us a few years ago, I think in 2017, after they have tried different ways. They went everywhere and they lost hope, and they end up turning up at Migrant Voice office. And when we listened to them and when we discovered, the huge injustice they were facing, we have decided, also Migrant Voice is also a platform for them to have a voice, to have a say, and to use their voice to fight the injustice they were facing. We're not a legal organization, so we are delighted to be supported by organizations such as Bindmans and Monckton Chambers, and also very important for us to be supported by Stephen Timms and his team, who actually helped us to have a voice in Parliament and gave us the platform and gave the students the platform to come to Parliament and to share their experiences and their stories with MPs and to build support for their cause and campaign. I guess I'll end here, and my colleague will say more about what we are doing in this campaign and how can students engage with us. But I'm, of course, available to answer any questions. Thank you.
Thank you very much, Nazek. Can I hand over to you, Stephen, to talk about what's happening in Parliament?
Thank you, John. Yes, I'm glad to, and I'm very pleased to be taking part. I applaud the website launch and the work of Migrant Voice and others in supporting this group of students. So I'm the MP for East Ham. I chair the Work and Pensions Select Committee. I also chair the all-party Parliamentary Group on Immigration Law and Policy, and I previously chaired the all-party group on TOEIC. In 2016, a constituent came to one of my regular advice surgeries. He told me he'd come to the UK in February 2011, studied for a diploma in sales marketing management. After that, he enrolled for a further diploma in business administrative management. But in June 2014, he was told his visa had been cancelled on the grounds that he'd cheated in his English language test, in his TOEIC test. And he told me in near perfect English that he, in fact, did not cheat. But he felt he couldn't return home without the qualification because his father had paid for his studies with the family's life savings. and he was in a position where he couldn't finish his studies, he couldn't work. He described himself as living in an open prison. And then a couple of weeks later, another constituent came to an advice surgery, no link with the previous one, but his story was very similar. June 2012, he took a TOEIC test in support of a Tier 1 visa application. 3 years later, he was told that his visa had been revoked because he cheated. Looking back, he could think of nothing irregular about the test which he'd taken in Mile End, but he was taken aback when the Home Office claimed a year later that he'd in fact taken it in Leicester. And other students, some who weren't constituents, started to get in touch. I was put in touch with Patrick Lewis, a colleague of Greg at Garden Court Chambers, and it was clear from talking to him that a lot of students had suffered a great injustice. I talked to Migrant Voice, who estimated at that time, I don't know what Nazek's view now is, but estimated at that time there were probably still a couple of thousand people in the UK who'd lost their visas because of being accused of cheating it in TOEIC. And the background was in 2011, this US firm, ETS, was given a license by the Home Office to operate its test of English for international communications, or TOEIC. 58,458 overseas students from 180 countries took that test in the following 3 years. And then in February 2014, BBC's Panorama exposed large-scale cheating with it. And test centres had facilitated proxies, allowing non-English speakers to gain a pass. ETS, when they saw the Panorama programme, said, well, it's okay, we can analyse the recordings using voice recognition software of everyone who'd taken the TOEIC test to study in the UK. They took 3 or 4 months over that exercise, and then they reported to the Home Office that of those 58,458 candidates who'd taken the test, 33,725 had definitely cheated, and 22,694 had probably cheated. So that was only about 2,000, or 3.5% of all those who'd taken the test who were given the all clear. Now, that seems to me a highly improbable conclusion, and somebody at the Home Office should have realised that something had gone badly wrong. I've certainly become convinced it cannot have been true. But the Home Office had no such doubts, seemingly. They responded by summarily cancelling the visas of all those that ETS had reported had definitely cheated. Colleges were required to expel them from their course. I met one student who went to college to take his final paper in his final exam, and he was told, sorry, your visa's been cancelled, off you go. Up to the end of 2016, the Home Office reported there'd been more than 35,870 refusal, curtailment and removal decisions made in respect of ETS-linked cases, and more than 4,600 removals and departures in respect of ETS-related cases. Students obviously weren't entitled to any fee refund. They weren't allowed to study or work in the UK. No appeal was available other than returning to their home country. And those who tried to go back home and appeal from there, as they were advised to, found it was in effect generally impossible. The allegations caused financial, emotional, family ruin, and a lot of those who are still in the UK are continuing to face huge hardship and in many cases, serious and completely understandable mental health problems. They feel their life has been ruined. So when I came across all this, I made inquiries with the Home Office. I didn't get very far. In the cases I raised, ministers refused to accept students' evidence of their innocence. So facing a brick wall from the Home Office in 2019 with others, I set up the all-party group on TOEIC, and we decided to conduct an inquiry into what had happened. I was keen the group should hear from all sides, we should hear from certainly the students affected and organisations who'd helped them, in particular Migrant Voice. And equally, we invited representatives from ETS and a solicitor and barrister who'd been involved in preparing cases on behalf of the Home Office. They all declined, as did the then Home Secretary Sajid Javid. But experts on voice recognition, on computer forensics, did give us important evidence. And the inquiry concluded that ETS's claims could not be relied upon, and that evidence against the students was, quote, confused, misleading, incomplete, and unsafe. There clearly had been some cheating that had gone on, but we simply did not believe that the evidence was reliable, and it still seems completely absurd to say that kind of 98% of those who took that test between 2011 and 2014 had cheated. A copy of that report went to the Home Secretary. I didn't receive a written response from him, but he later told me he took the issue very seriously. He asked his officials to review the report and promised further meetings to make a final decision. And I think he did. This was Sajid Javid. I think he did intend to introduce a mechanism to allow innocent students to clear their names. He made a written statement in the House of Commons which suggested that. But unfortunately, in a cabinet reshuffle, a week after the report was published, he was promoted to Chancellor of the Exchequer, albeit not for very long. But since then, ministers have largely been unwilling to engage with the TOEIC issue beyond individual cases. In March last year, the Immigration Minister, Kevin Foster, told me that even if a student thinks they are not entitled to a human rights claim under normal rules, they should still apply for one. Having been refused, they could then appeal. And he made the point that this would open up a route through via a court determination for TOEIC victims. And I suppose that was something, but it can cost £10,000 to £15,000 in legal costs. So it wasn't a very satisfactory answer. But I've had more encouraging conversations since talking to Kevin at the Public Accounts Committee, the 10th of September last year. The recently appointed Permanent Secretary, Matthew Rycroft, gave the impression that he agreed with me that there should be a mechanism for innocent students to clear their names. And then answering the Conservative MP Tim Loughton at the Home Affairs Select Committee on the 24th of February this year, the current Home Secretary, Priti Patel, did adopt a different tone from what she said previously. She acknowledged that a resolution needed to be found. She told the committee, and I quote, "We do need to look at this. We still have a number of people, too many people, who are caught up in this, and we need to find a resolution and actually to bring not just clarification, but also some justice around what has happened." And that was a very encouraging development, a very different tone from what she and her fellow Home Office ministers had said previously. 2 TOEIC cases were discussed at the upper tier tribunal in March this year. The tribunal is going to rule on the admissibility as evidence of transcripts from our all-party parliamentary group meetings on TOEIC. The Home Secretary referred to those cases in her evidence to the Home Affairs Committee, and she said she'd decide what to do once the cases had been determined, and she would then write to the Select Committee with her decision. I think we'd all hoped that those cases would have been determined by now, but they haven't yet been. I hope they soon will be, and then we might see where we've got to. The mechanism that Sajid Javid envisaged could resolve this issue, I think, once and for all, and end the misery for hundreds, if not thousands, who are stuck in limbo. Needn't be complex, needn't be large scale, could be achieved within existing Home Office systems. And it is the very least that ministers, in my view, should do. There is, of course, the question of compensation, which people are absolutely understandably now turning their minds to. But my focus has just been enabling innocent students to clear their names after this 6-7 year period that they have had to endure. It does look as though this has all been dragged out in the hope that students would simply give up and leave the UK. And I'm glad very many have not done that, choosing instead to stay to fight their corner. And I very sincerely want to thank Migrant Voice, Bindmans, Garden Court Chambers, and many others who've been willing to help them through this dreadful experience. International students wrongly accused of cheating have suffered huge distress and hardship and have been left to feel like criminals. They've endured all of this. They deserve answers for what's happened to them. They've honoured Britain by choosing here to come and study, and we, I think, have a duty of care to them, which so far we have failed to discharge. The change in tone from the Home Secretary was, I hope, the first step in finally resolving this dreadful scandal. Thank you.
Thank you so much, Stephen. That's a really helpful bit of background to the parliamentary activity, which is absolutely critical. Ultimately, as you've said, a simple mechanism is not something the law provides at the moment at all, and yet it is in the gift of the government to set that up and bring the facility for people to clear their names and achieve that measure of justice in a relatively straightforward way. So let's hope that isn't too far off. So I'm going to hand over now to Cameron Ball, who's Migrant Voice's TOEIC campaigner, to talk a little bit about that organisation's particular campaigning focus for the next 10 minutes or so. Cameron, do you want to unmute yourself?
Yeah, hi everyone. As John just said, my name's Cameron Ball. I'm the campaigns organiser at Migrant Voice. I first started back at Migrant Voice in 2019 now, I believe it was. Went away for a little bit, came back at the end of 2020 and have been working on TOEIC during all of that time. Like everyone, when I first heard about the TOEIC issue, I was shocked. I couldn't really understand it, couldn't believe it. But meeting the students face to face, you know, it was shocking to hear some of these stories and how well the individuals who we worked with spoke English and they were being accused of cheating on a test. It just didn't add up. In 2019, just before I started, we had launched a report called My Future Back, which got a large amount of attention. It was sent round to many MPs and we worked with Stephen as well as other MPs, lobbying them to sign an early day motion and helping Stephen form the all-party parliamentary group on TOEIC, which we were the secretariat of, and helped out of those hearings. And that was a period when we started to really see a change. And like Stephen said, it was really unfortunate that at that time the leadership of the Tory party changed, and with that the cabinet, and our hard work kind of got reset. Since then, Migrant Voice has continued to campaign and really have been pushing hard on the Home Secretary and the Prime Minister. We've done numerous open letters, numerous action days, lobby days, worked with students individually to send letters to their MPs to try and get them to put some pressure on the Home Secretary. During COVID, though, with everything that's gone on, everything's really slowed down, unfortunately. One of the things we have done during that time is we worked with some of the students, continue to produce stories for the media. We've still been pushing out regular little profiles, but the problem is with this being now a story which is 6 years old, it's very hard for the media to find a new story which hasn't been covered before, or a new angle which hasn't been covered before, and something they can really new and interesting to hook that story to. What we did do during that, though, is work on some longer pieces with some publishers who are producing a book on the hostile environment. We got three of the students we work with to write about their experiences, and that's going to be in a book which is going to be published on later this year, I believe. We continued to campaign regularly, and we hope to return to that as soon as possible. When Parliament opens back up, we can get back in there for a lobby day. We'll be sorting that out as soon as possible to try and get everyone back in there and putting a bit of pressure on the government again to make a big change. And it might be some big action outside. Last time, I think it was my first day at Migrant Voice, I was forced to dress up like an immigration officer during a stunt, which was great fun on a first day, but it was really good. We need to do things like that really catch the media attention. We're still looking for more students, and if there's anyone who's attending the event who isn't on our list, please contact me. I'll put my email in the chat at the end, and we'll get you on a list, and we'll get talking to you and see what how we can help each other on that. What we have been seeing though from a lot of our students is some real positivity. In general, I've got a list of all the students we've been involved in. It's slowly turning green with those who've got visas back, bit by bit, and it's really starting to go forward. And it's really great to see. An increased amount have got indefinite leave to remain. A few have even now managed to get citizenship, and it's really brilliant to see that progress on. We still have problems with some students who receive only 6 months visas, and there's no way that they can get a sponsor in that time. As Stephen also alluded to, we worked during the lockdown on the we acted as interveners in the RKDK case, which has been talked about already. As Stephen said, Priti Patel hopefully is going to make a statement once the decision that comes out. Our understanding as it is that due to us quoting a ministerial statement at one point in the APG report, that it is ineligible in court because of parliamentary privilege. What they have concluded, as we understand, and this is still yet to be officially drawn out and released, is that the transcript from one of the sessions we had with the experts, so the language experts, the recording experts, the computer experts, that is admissible in court. Now, it's a real shame that the APG report isn't admissible in court, because we've seen numerous students use that and it's got them positive results. We're hoping that the evidence that is gained from the transcript will do the same thing. It's still a very strong piece of evidence, and if anyone does need that, while we haven't put that out completely publicly yet, we're going to wait for the final result. If people need it pressing for an urgent upcoming court date, then we can release it onto you. We're quite happy with that. Other than that, we're going to continue doing what we do. We're going to try and reach out to more members of Parliament. We're going to try and reach out to Lords. We're going to try and reach out to journalists and get as much pressure building on this as we can. And it's really great to be able to kind of work with Bindmans on this project to kind of add another attack line that we can start to go at the government with, and hopefully we'll be able to get a result, not only going through the courts, but also a political result, which means that we can get justice for the 50,000 plus students who are affected by this. Thanks very much, John.
Thank you, Cameron. That's great to hear about. So the next speaker is my colleague Theo Middleton. Theo has been involved with TOEIC cases for pretty much as long as she's been at Bindmans, and even when she was a trainee and moved to the immigration team, she didn't manage to escape them, because she then ended up taking TOEIC cases in that capacity. And now she's back in my team in public law, and she's involved in helping people explore the possibility of seeking compensation. And Thea's going to talk about the basic principles and what's involved in the process of that. Of course, it's really important to bear in mind that compensation is not really capable of addressing what's happened to those who've been affected by the curtailment of their leave or deportation. The law is not equipped to put people back in the position they would have been in had they not been falsely accused of cheating on TOEIC tests. But it might make a start, and it might help people deal with the after effects to some extent. So Theo's going to explain how that might work.
Thanks, John. I actually thought I was going after Greg, so I was a little bit relaxed there. But I'm very pleased to go now. So here, hopefully you can see my screen, my slides. Okay. So as John said, I'm going to talk briefly about compensation claims for people who've been wrongly accused of cheating on their TOEIC tests. And so Bindmans is acting for a group of people who are claiming compensation. We're working together with Greg and Julianne, who are both going to speak shortly, and also with another barrister called Richard Hermer. We've heard a bit about the horrendous impact of false TOEIC allegations on people accused, and the long fight for justice. As many of you in the audience are all too aware, people lost everything as a result of the decisions of the Home Office and the false allegations against them. The long fight for justice has left most of those people with massive debts, as well as with mental health problems, damaged relationships with their families and partners, and often still without the university qualifications that they came here to get many years ago. So getting your immigration status sorted out and having your rights restored is essential. And it's fantastic to see so many people finally achieving this after so many years of fighting through the courts, in Parliament, and as part of the campaign groups. As Cameron said, you know, we have also seen most of the clients that we've worked with now finally getting through to the point where they have got some form of leave restored, and are even getting through to getting indefinite leave to remain or citizenship. But this doesn't fix everything. What can we do now to rebuild the lives that have been shattered by the TOEIC scandal? Those affected, even once they have proved their innocence, are left picking up the pieces with little recognition of the suffering and damage that the Home Office's actions have caused. As John said, you know, compensation can't bring back the past 7 years of people's lives, but it is an essential part of enabling people to start rebuilding and putting things back together. It's very difficult to start again when you've got tens of thousands of pounds worth of debt built up from years of legal fees and being unable to work. So that's why we are acting for people who are claiming compensation. Okay. On what basis can people claim compensation? It is a bit more complicated than you might think, or than we might want it to be. The injustice of the TOEIC scandal is so stark, and the losses are so serious, it feels like it should be straightforward to demand compensation. There is a significant injustice here of a kind that we would expect the law to be able to remedy. But the route by which this can be achieved in this situation is not clear-cut. There's no direct precedent for this scandal, but there are established legal remedies available for breaches of human rights and for other legal wrongs. if it can be shown that the Home Office committed these legal wrongs and that this caused the losses to those who were falsely accused, they should be entitled to compensation, which could help with the process of starting to rebuild their lives. There are 4 types of claim that we think are possible, and one other that's mentioned on the slide for completeness. So firstly, a claim under the Human Rights Act. So under the Human Rights Act, it's possible to claim damages for breaches of your human rights. The main human right in issue in the TOEIC cases, as many of you will know, is your rights under Article 8, which is your private and family life. So where your leave to remain was curtailed without any proper evidential basis, and when you did not cheat on your test, this was an interference with your private life, and that interference was unjustified because you didn't cheat. That breach then continued for years while you were fighting to try and clear your names. And so we believe that you're entitled to compensation for that breach and for that extended period of time. The Secretary of State had mounting evidence, about which we may hear some more, that the initial basis of her decisions was completely unjustified, and she had many opportunities to change her course of action, and she didn't do so. In some cases, this is still ongoing. She continues to fight appeals in the Immigration Tribunal, and I know that there are some people in this audience who are still fighting their cases in the Immigration Tribunal, despite the overwhelming evidence that the original allegations can't be substantiated. The second type of claim mentioned there is claims under the Data Protection Act. I'm not going to say anything more about that because Julianne is going to talk more about that in a bit. Thirdly, misfeasance, which is a claim essentially that the Home Office was recklessly indifferent about whether what they were doing was legal or not, which means that they didn't care whether or not they had good enough evidence to take action against people. And they knew that in doing that, they would cause serious harm. This claim is a bit more complicated than the first two, but we think it is a possible claim in these cases. Fourthly, false imprisonment. So some people were detained based on these allegations with the intention of removing them. Some people were in fact removed, other people were subsequently released. But where somebody has been detained by the Home Office based on the allegation that they cheated on a TOEIC test, they should have a claim for false imprisonment. I've also mentioned negligence on the slide, as this is something that we have considered and that people have asked about in the past. Bringing a claim for negligence against a public body is very difficult. There are some recent developments in the case law which may make this more feasible in the future, but it might be too late for forming a basis for the TOEIC compensation claims. Time limits. Again, many of you will have had to become aware over the last few years of legal battles that time limits are extremely important in the law. There are different time limits for different types of legal cases. So lots of you will be familiar with the 3-month time limit for your judicial review cases, 14 days for your appeals. In compensation claims, time limits are a bit longer. So for a human rights claim, it's 1 year less a day. For the Data Protection Act and for the misfeasance, it's 6 years. For false imprisonment, 6 years again from the date of detention. In some cases, people may have claims for personal injury as well, which means that the Home Office's actions have either caused or have made worse a physical or psychological injury. And these claims need to be brought within 3 years. The courts can, in some cases, extend limitation, has the discretion to extend limitation, but this is used sparingly. Now, because of how long this scandal has taken to unfold, we're very aware that for many of you, those deadlines are either very, very soon or may already have passed. And that is why we would recommend that you speak to a lawyer as soon as possible, not necessarily us. You can speak to other lawyers as well and get some advice about your position. We think that claims, calculating limitation is complicated, but we think that claims should be brought, if possible, within a year of the date that you're successful in your appeal in the tribunal, or within 6 years of the date that the Home Office first took action against you, or if you have a false imprisonment claim, within 6 years of the date that you were detained. A lawyer will be able to advise you on whether there's sufficient prospects of success to bring a claim out of time. Because of the ongoing and long-running nature of what happened, it's likely that parts of your claim may still be in time, even if other parts of it are no longer possible. Funding. So we're currently acting, our client group is almost entirely funded under legal aid, and legal aid is available for certain types of compensation claim, including these against public bodies. You do need to be financially eligible, which in most cases is going to mean either that you're on benefits or that you have a very, very low income. The thresholds are very low. We are really happy to assess anyone with the legal aid if you're not sure whether you'd be eligible. And I've included on the slide there a government calculator that you can use to check whether you're likely to be eligible. If you are eligible, then the government will fund your legal costs, and you would also be protected against the costs of the Home Office. So it's definitely the best funding arrangement if it's available to you. We are aware that many people are not eligible for legal aid, but would still want to bring claims. And we're currently considering how this can be made possible for those who do not have enough money to fund their cases privately, but are also not eligible for legal aid. So finally, what are we doing? Just in brief, we currently have around 20 clients who are bringing claims against the Home Office. We want to arrange the cases so that it's not just one case after the other going through the court. The idea is to put all the cases together under something called a group litigation order, which is an arrangement with the court by which some cases will be the lead cases, and other cases will effectively be stayed behind those so that the key principles can be worked out in the lead cases without everybody having to go through the process. We do have capacity to take on some more clients, so do get in touch if you think you may have a claim, but we won't be able to help everybody because there are many tens of thousands of affected people. However, we do hope that whatever positive outcomes we achieve for the group that we are able to represent is going to have benefits for everyone else. So I think that's everything from me. Thanks, John.
Thanks very much, Theo. The other thing I think we would just say about compensation claims is that in an ideal world, which is not the world we live in, the government would set up some sort of scheme to deal with those as well that would be fair and accessible and wouldn't require very much input from lawyers, if any. At the moment, there's no indication that the government's inclined to do that, but perhaps that will come down the line. There is such a scheme established for Windrush affected people, but that hasn't really covered itself in glory. So it's not really an ideal precedent for the TOEIC scheme. And then the other thing that might happen, which would also be ideal really, is for there to be sort of negotiated settlements on these cases. And we are pushing the Home Office very hard to try and have discussions with us about how cases might be resolved without having to be dragged out through the court process over a further period of years. But we're early days on that, and we'll just have to keep our fingers crossed and see what happens. So I just wanted to, before turning to the final speaker, who's going to be Greg, on the sort of state of play in the immigration cases that are still ongoing that Theo mentioned, I just wanted to hand over to Julianne, because one very unusual feature of the TOEIC cases is an argument that we've developed based on the data and information rights of the TOEIC victims. And it feels a very unusual way to be arguing these cases. But if you think about it, at the heart of the TOEIC scandal is a problem of the way people's identities and information about them was effectively dealt with wrongly to categorize them as something that they were not. And data protection law is now very developed in this country and in Europe, and it may well offer effective answers to the injustices that for which compensation can be claimed, which again are not certainly not all of the injustices suffered by people. And Julianne Morrison's going to say a little bit more about that now.
Thanks, John. So you've already heard a really helpful overview of the nature and types of claim from Theo. And as John said, I'm going to really focus in and discuss the sort of the data protection angle that we're pursuing for the clients that we already have. I'm going to talk about sort of three main points, really. The first one is what is the relevant regime? And second, I'm going to talk about the nature of the likely breaches, and so therefore the nature of the compensation claims under the Data Protection Act. And then finally, I just want to make a couple of points about quantum in this area, so you have a sense of what the regime actually involves and what you might get compensated for. So first, talking about the relevant regime, I'm sure many of you have heard of the GDPR because it was covered a huge amount in the press. In fact, suddenly it became something to be known to be a data protection lawyer, whereas before you were a bit of an oddity before the GDPR came in. But there was so much publicity around it, you'll probably heard a lot about that regime. But given how long this process has actually been going on for the TOEIC victims, it's probably not the GDPR that would actually apply to your cases in claims for compensation. It would in fact be likely to be the old regime, or what was called the Data Protection Act 1998, which was the predecessor regime. And there's a particular right to compensation that is guaranteed by that act under Section 13 of the 1998 Act. And for any sort of cases that arose before 2018, when the GDPR came in, you still have to bring your claims under the old Data Protection Act 1998. Now, there is some benefit to being under the GDPR. It's much clearer under the GDPR that you have a right to compensation for any material or non-material damage caused by a breach of your data protection rights, which is a nice, clear-cut right. But in my views and the view of others, it's unlikely to make much difference to the types of claims we'd be bringing here. It's clear that under the Section 13 of the Data Protection Act, you can bring claims for distress and pecuniary damages or financial damages caused by someone failing to comply with the Data Protection Act. And given the history of these cases and the amount of distress that's been caused, the personal injury that's been caused, and the financial losses that have been incurred, it's unlikely to make much difference whether or not you end up bringing a claim under the old regime or the new one. But it is relevant to know that you are going to be bringing the claim under the Data Protection Act 1998 rather than the later regime. But you'll also still be able to rely on some really strong case law from Europe, the European courts and others that really stress how important data protection rights are. I think data protection has always been a bit of a sideshow, not something that many people know about, not often brought in these types of claims. Normally the focus is on human rights claims. But we have begun to recognise, particularly over the last few years, how important they can actually be in all kinds of different situations, and sit alongside, human rights claims that we're all more familiar with or are used to hearing about. However, if anything has arisen in your case since May 2018, you may have a claim that's brought under both regimes. So turning to topic 2, I wanted to talk about the nature of the data protection claims, what the breaches, what the likely principles are that are going to be relevant, what the breaches would be, and therefore what you'd be asking for compensation for. There are 3 main data protection principles that are really at issue in this case, or really bite on the facts of the TOEIC claims. The first is that a data controller must process data lawfully and fairly. And immediately you already know how many legal issues there are with how they've been behaving over the last couple of years, but also how unfair they've been in not taking steps to address different cases, even when they were put on notice that the data that they were relying upon was likely to be incorrect, the data they were relying upon from ETS. The second one is even more pertinent, and that is that a controller is required to process data that is accurate. And the third one, which links in very neatly, is the one that they're supposed to have appropriate measures in place to ensure that any processing they do is done lawfully. So they're supposed to have processes in place that help them verify and act upon any inaccurate data. But as we've already heard from others speaking tonight, the history of this process really is that they've put their head in the sand repeatedly. They've just relied on data that was handed over and said, right, that means they're a cheat. And no matter what evidence has come up at each stage in this long process that has said, well, there's doubts or anything else, they've never actually put in place proper policies and processes to do anything to correct the data and then act upon accurate data. It's only when their hands have been forced in each individual case that they've actually then changed the position for each individual. So we'll be really targeting each time they have failed to act upon even new information that further corroborates that there was inaccurate data that they were relying on from the start. So those are the kinds of key points that we'll be kind of making the data protection claim. And as John said, even though it feels a bit unusual at the start to think about it as a data protection issue, what really permeates this entire situation is a failure of the Home Office to take responsibility for the data it's relying upon and whether it's right or wrong. And so the Data Protection Act provides a really clear framework to try and get compensation for each time that the Home Office as a data controller under the Act, has failed to comply with these principles. And as you'll see, there's been many instances of that over the years, and we'll be looking to recover any damages that can be linked to each of those specific types of breaches. So then finally, coming on to my third topic, because I'm very conscious of the time, there isn't actually a huge amount of case law on the scope and quantum of damages, so actually how much money an individual should be able to recover for breach of their data protection rights. But I wanted to stress a couple of key points. I think the first point is that claims for distress damages in this area, even if there's no personal injury claim, should be quite significant. And I say that because this has been a long, protracted battle that has obviously destroyed lives. And if there's any type of case where distress is going to be given a meaningful value, it seems to be this kind of one. Because to give you an example of a case where £5,000 was awarded, Mr. Burrell, the old butler of Princess Diana, managed to get £5,000 out of the court because he shared a letter with Max Clifford that he was actually thinking about selling a story to the press about. Unbeknownst to him for many years, Mr. Clifford shared that letter with some journalist, but nothing happened with it. He then Mr. Burwell then wrote about it in his autobiography, but then found out after that fact that Mr. Clifford had breached his rights by sharing it before that. And even though it's actually quite difficult when you read the judgment to figure out why Mr. Burwell would be remotely distressed by that, because he was and gave evidence of it, he managed to recover £5,000. And to me, if that's the starting gate for sort of distress, and you think about some of the just significant harm that has bitten on each victim of this scandal, and you think about the number of likely errors that are likely to have been committed by the Home Office, because they didn't just process inaccurate data once over the course of the past 6 to 7 years in many cases. It's been multiple times and multiple failures to do it. The distress damages should be an important part of this case. The second point is that it's been generally recognised, at least in equivalent compensation contexts, that there's increasing recognition of the importance of privacy and data protection rights. And so the trend of awards is upwards. It used to be about 10 years ago that awards could be really, really small, even in quite egregious cases. But there's a case called Galati that went all the way up to the Court of Appeal, where it was made clear that there's a real value to your data being accurate, as is amply demonstrated by this case. And so you should be able to, you shouldn't be looking at some of the old Human Rights Act cases where sometimes even quite egregious breaches of rights only recovered a few £1,000s. There is one judgment to flag, if anyone's interested, that will be coming out soon, a judgment of the Supreme Court in a case called Lloyd and Google, which might have something to say about the scope of damages under Section 13 of the Data Protection Act. Actually, what's at issue in that case is when actually data has been lost and it's had an almost minimal or non-negligible impact on the individuals involved. So my personal prediction is that it won't really have much to say or bite upon the kinds of cases that are being brought for TOEIC victims, because they're at the other end of the extreme. But it's always worth knowing that there's a judgment in a particular area that's coming and may have something to say in some guidance. My third point is that there is some evidence in the court's case law that they may not be willing to make such large awards against public authorities as opposed to commercial enterprises. There's always a slight element of the public purse concerns in the background. But I would note that that was in a case called TLT, where what happened was the Home Office made a single mistake of putting a spreadsheet online that contained data that shouldn't have been there. They corrected it within a few days, and there was relatively limited evidence of impact. Just working on these cases for the period that I have been, I've not been involved as long as others, but it's perfectly clear there's going to be huge amounts of evidence of harm on an ongoing nature, and to be honest, some pretty clear-cut failures by the Home Office to act on clear indications that they are relying upon inaccurate data, or that they at least should inquire into whether they're relying on inaccurate data. So in my view, cases like TLT shouldn't really bite. In these kinds of cases, it should be a very clear-cut argument that the distress damages and other awards of damages should just fully reflect the losses that have been incurred. But these are just some of the points that need to be brought to bear. So really, in summary, the key points I want to make about the Data Protection Act is it may feel like something that you're aware of mostly as an irritant because you get asked to consent to all kinds of things now when you're ordering things online or something like that. But the real power it has in this kind of case is it puts the onus on the Home Office to prove that at all times it's been lawfully processing your data. And given the history of this case and how much inaccurate data has been relied upon, it gives a really solid basis to go in and say there must be compensation for all the damage that's been wrought by false allegations being perpetuated for a number of years without anyone ever doing any proper work to figure out if they were making those allegations on a correct basis.
Thank you very much, Julianne. I think people who've been on the receiving end of TOEIC decision making by the Home Office who never cheated in their tests will see that there's some irony in the Home Office being put in a position where they have to justify to the court that they have been lawfully dealing with data all along at each stage of this long process. So the last speaker before we deal with questions is Greg O'Connell, who's a barrister at Garden Court Chambers, who is both involved in the damages claims that you've been hearing about, but also on immigration appeals and judicial reviews intended to achieve what the simple mechanism that Stephen's been pushing so hard to get in place can achieve at the moment, because that mechanism is not available. So Greg's going to talk a little bit about the current state of the case law on immigration status, and then we'll conclude by taking some questions. And if people do have questions, please do put them in the Q&A chat box, which is towards the bottom right hand of your screens. And we'll do our best to get through as many of those as possible before we finish at 6:30. So over to you, Greg.
Thank you very much, John, and thank you to everyone who's spoken so far, and thanks to Bindmans and to Migrant Voice for inviting me to speak today. This is an issue that's incredibly close to my heart for the past 5 years or 6 years, really. And it was striking to me to see to hear so many people talking about their experiences of meeting TOEIC victims for the first time. And I represent dozens and dozens of TOEIC victims now, but I'll never forget the first time, which is essentially took the case as a favor to a friend and went to a conference in Luton to meet the client. And there was a bit of a delay at the start, so I ended up sitting just with the solicitor for about 20 minutes chatting before the conference began. And then after a while, the solicitor arrived, and I realized I'd been talking to the person accused of faking the English language test for 20 minutes. This man had absolutely perfect English. And the idea that he would have paid someone to sit an English language test for him was so ridiculous that I couldn't believe that anyone could possibly have done it. That was Mr. Nabil Hassan, who ultimately had the case in the Court of Appeal that led to everyone having a right of appeal. So I think it's important to look at where we are and where we've come from, really, in terms of case law, because while it's true to say that there are still a lot of people suffering a great deal, it is also true to say that a lot of progress has been made. So I know you've all been desperately hanging on for the case law chat, but I'm going to have to go through slightly quickly so that we have time for questions. The three things I'm going to look at are what things were like, just to give us a bit of contrast, where we are now and where I think we're going to go. And I'm going to cover the RK and DK issues that some people have raised, a man has raised in the chat. But first of all, in terms of where we were, now, when we started off, the evidential picture was this. The Home Office always relied on the reports of Peter Millington and Rebecca Collings. There was no chance of getting the voice files at all. If you asked for them, you'd be told no or flatly ignored. The view of the tribunal of the strength of the Home Office evidence was this: the evidence upon which the impugned decision was made has the hallmarks of care, thoroughness, underlying expertise, and sufficient reliability. The key evidential issue at that stage was the reliability of the voice recognition software. So what people would generally be arguing would be, well, how do we know that you have correctly concluded that my voice isn't on the voice file? And of course, you'd be demanding to hear the voice file, and it was never made available. What was the position on remedies at that stage? Well, you couldn't bring a judicial review on a precedent fact basis. Was ordinarily, of course, if you were accused of fraud, you could bring or having obtained leave by deception or entered unlawfully by deception, you could challenge that on the basis that the factual premise was wrong, i.e. you weren't a fraudster, you hadn't done things wrong, you weren't an illegal entrant. But there was an exception to that where there's an out-of-country remedy, and it had been held clearly that an out-of-country remedy was adequate in the context of a TOEIC appeal. Any Article 8 claim will be certified as clearly unfounded, stifling an in-country right of appeal. Of course, that's what happened to Mr. Hassan. The Home Office would say, well, you may say it's a breach of your human rights, but we know you're a fraudster. And the chances of you proving that wrong are zero because our evidence is so reliable. The Home Office deliberately didn't give people notice of their suspicions, because if they did that, those people would make human rights claims which might trigger a right of appeal. And also, I think Mr. Mohabullah is actually one of the participants today. They had this particularly sneaky method with some people of, instead of cancelling their leave and so facing a direct challenge, what they'd do was they'd write to their college, tell the college to kick people out because they were cheats. and then simply curtail their leave on the basis they're not studying, and tell people in writing, well, if you've got a problem with that, you can sue the college. When somebody won an appeal on the basis that they didn't cheat, they'd often be granted 60 days leave to remain to get another college, which was virtually impossible because anyone who's in any way tainted by the TOEIC scandal, even now, will find it very hard to get a college. And where an appeal was dismissed and they're found not to have cheated, they'd also get a grant generally of 60 days leave to remain at best. Where we are now, there's been a lot of work since then by a lot of lawyers, not least Bindmans, and a lot of credit has to go to a lot of the people who are here this evening, as well as other people such as Salima and Rebecca, who aren't here today. But the current TOEIC case law situation is this: in respect of evidence, the evidence of Middleton and Mr. Middleton and Ms. Collins is highly doubtful, as I think should have been obvious at all times. They're essentially civil servants who went to America to speak to ETS and were talked into accepting everything that they said. The tribunal had substantial reservations about the strength and quality of the Secretary of State's evidence. Its shortcomings were manifest, and the information the Home Office had at that stage was only adequate by a narrow margin to even require an answer from a person accused of fraud. However, since then, the voice files suddenly became available, despite the initial response from ETS being, oh no, they're not available because we only keep them for 2 years. Suddenly they're always available, obtainable via Jones Day. And the Home Office would turn up at an appeal and say, aha, well, your voice file doesn't have your voice on it. And we've also got this evidence that your college was a fraud factory. They still do this now. They'll produce an operation facade report, which will show that the majority of the tests at your college were invalid or questionable, and will say only 3% were held not to be questionable or invalid, which means that it's highly likely that you're a fraudster. What they don't point out is that, as Stephen referred to and set out at the beginning, almost everybody who took any test on any day in any college was said to either be a fraudster or to probably be a fraudster. So that evidence is essentially useless because, as there's often said about statistical analysis and models, if you put rubbish into the model, you get rubbish out of the model. The key evidential situation is now set out in the test cases from Mohabullah, Saha, and MA, and the expert evidence relied on in those cases. Evidence was heard from 3 experts there, including the Home Office's own expert, and many issues were raised with the ETS process. But I'm hesitant to say this now because I've seen Peter Summer is literally here. But my view is that the most important issue there was that the experts were unable to determine how individuals accused were linked to the relevant voice test. So unable to say in any case how an individual has been connected to a voice file. And if so, whether that's a result of cheating, if the voice file has been correctly allocated and it's not your voice on it, whether that's in fact because you've been cheating or because the college has been cheating for its own convenience, filling up a room with proxies next door because some people were cheating in the room with you, or simply replacing voice files en masse or whatever it was. Now, I've been asked a bit about DK and RK in the chat, I know by Amam and by others. The current situation is actually that the judgment has been given already in RK and DK on the issue that Stephen was referring to. Judgment was given in March, and the conclusion was that the conclusions of the reports of those parliamentary bodies could not be relied on as evidence themselves, but the information given to the parliamentary bodies in terms of the reports of the experts, such as Peter Summer, could be relied on, which I think is correct. Now, the confusion may arise from the fact that there is a second RK and DK case. That judgment was only a preliminary decision because the real meat of RK and DK is challenging, as I understand it, the question of whether or not the Home Office evidence, taking into account the absence of any chain of evidence, as I've already referred to, between an individual taking a test and the actual evidence that ETS has, whether the Home Office even meets the initial evidential burden. So, the joint report was summarised by Professor Summer in his Evidence of the Home Affairs Select Committee as follows. And the key points was that we agree that in any one testing session, there could be a mix of genuine applicants and those who are paying for fraudulent results. And it seems reasonable to conclude that the ETS test lists are not a reliable indicator of whether or not a student, in fact, cheated, which is, an extraordinary state of affairs. So the current test is when you go to the tribunal, the respondent has to produce their generic evidence, and as they always do, taken together with a lookup tool, and that discharges the evidential burden of raising a case to answer. I don't think it does, but as the case law currently stands, generally I would reserve my position on that, because you don't want, it's easier to just win the case and accept that that's the way the case law stands than trying to argue about that. Certainly pending the decision in RK and DK. But it is notable that sometimes the Home Office doesn't produce the generic evidence. I had one a couple of weeks ago where they just didn't bother on the day. And we were able to argue, well, you don't even get to the first hurdle. The second point about that is the Home Office practice is to produce the lookup tool, the statement of Collins and Millington, the statement of Professor French, which is totally irrelevant now that we have the voice files, and a project facade report, and the lookup tool on the day of the hearing or the day before. And the thing that I've done in a number of cases recently is just to say, well, under the procedural rules, you had to produce this stuff months ago and you didn't bother, and there's no good reason for it. And you've had this evidence for, in often cases, 5 years. And I've actually managed to get in a couple of cases their evidence excluded completely, which is an even better way of winning quickly. But by assuming they get to do that and we get that far, the appellant has to raise an innocent explanation. Now, repeatedly, I've seen the respondent argue, sometimes successfully in other cases when I've been asked to take over the upper tribunal or the Court of Appeal level, the Home Office will have argued an innocent explanation means the person accused has to explain to the tribunal how the fraud happened. You're required to explain how is it that your voice file is the wrong voice file. And of course, Peter Summer and the other Richard Highway and everybody who looked, all the experts in all of the test cases, were unable to say how any individual's case was matched to any individual's voice file was matched to that individual. So, if none of the experts could do it, the idea that the victim would somehow be able to explain how the wrong voice file ended up attached to their name is I would say absurd. What they actually have to do is just give an account of having taken the test themselves that meets the minimum level of plausibility. So that means explain that they took the test themselves in a clear and coherent way. And then the test is still the test in Majumdar, which comes from SM and Kadir in applying the legal burden. And the Home Office, when the Home Office coming to prove their case, can the Home Office prove that you're dishonest, taking into account what they had to gain, what they had to lose, what's known about their character, the cultural environment in which he operated. So, for example, were you somebody who was a religious person who was regularly giving sermons, which makes it slightly unlikely, perhaps, that you would be prepared to be casually dishonest. How they performed under cross-examination, the tribunal's assessment of whether your English language proficiency at the relevant time is commensurate with your scores, and whether your academic achievements are such it was unnecessary or illogical to cheat. As to remedies, we're in a much better position. ASAN establishes that an out-of-country appeal is not good enough for the common law. It's not good enough for Article 8. ASAN establishes that you can't certify an Article 8 claim on the grounds of TOEIC fraud solely on that basis to be clearly unfounded, so you get a right of appeal. And where a person establishes that they don't cheat, then the Secretary of State has to treat you as if the error hadn't been made as far as possible. So that may mean a new grant of leave. In the Khan case, the Home Office undertook that if your leave had been curtailed, and where that would have expired anyway, because you didn't make a new application, why would you? Your leave had been curtailed. The FTT determination would have the effect that the refusal would be withdrawn, and you'd be given, you'd have a further chance to make an application for leave. And in any future application, the respondent accepted that they wouldn't hold against you any previous gap caused by an erroneous decision in relation to ETS. We also have quite a helpful policy now, and as a result of the Mohambullah case, which I did with Theo and a couple of people at Bindmans, including Rebecca, we established that where an appeal is successful on the basis the accused person didn't cheat, they'll generally be granted 2.5 years discretionary leave to remain, instead of what it was previously, which was sometimes only 60 days. Where an appeal is dismissed but a person is found not to have cheated, they will get the grant of 6 months leave to remain. And I've noticed a few people talking about how inadequate that is. Actually, there is some recent case law that may help on that. The Hock case in the Court of Appeal establishes that when you're over, in respect to the 10 years rule, if you made an application in time, a gap in the middle may not be held against you. If you take that point in conjunction with the Khan case, and with conjunction of some of the more recent upper tribunal case law, which says that even time when you didn't have leave to remain, if that may be taken into account for the purpose of a 10-year application, if ultimately your application was successful. So if you made an application in time after leave, within 14 days, say, after leave being curtailed, even if it took 4 or 5 years of TOEIC litigation before you actually got your leave to remain, you may be able to rely on 10 years for that, for further leave. So what's coming down the tracks? There are a bunch of issues I see now in the tribunal all the time that need to be dealt with. One is the Home Office routinely arguing, for example, that the fact that your English is good and your English was always good and you're a great student is irrelevant, relying on MA. And that's because in that case, MA was found to have no reason to cheat, but it cheated anyway. I think that's a really problematic decision, and it was relied on by Mr. William Davis, Justice William Davis, in the Abbas case, who also said, well, we don't need to worry about what your motive was for cheating. Actually, Majumdar is really clear that if you had no reason to cheat, that's a relevant factor in determining whether you cheated or not. I mean, the reality is that Mr. MA was so hopelessly lacking in credibility that the fact that he didn't need to cheat was irrelevant, but generally that won't be the case. There's also the suggestion in Assam where Underhill said that, Lord Justice Underhill said that where the impugned test was taken in an established fraud factory and the voice files don't record the applicant's voice, the case that he or she cheated will be hard to resist. But when he said that, he was recording the statement of Elisa Giovanetti QC for the respondent. And the Secretary of State often argues that that is a new higher threshold. It's not. The court in Assam, as they say very clearly, heard no evidence at all. It's an obiter statement, and the only reason that he was commenting on it was that Lisa Giovanetti had accepted that even in such especially strong cases, in her words, it would still be necessary to hear from individuals, so it wasn't necessary for the court to look at any evidence. The other issue is that, the other really important issue I think is that, and you see a lot of cases where the Home Office, as I said, relies on the reports of Peter Middleton, Rebecca Collins and Professor French, and then says, well, Professor French shows that we're 99% likely to have got the right answer because the voice recognition software is 99% reliable. The Home Office routinely puts that evidence in without drawing the tribunal's attention to the fact that the evidence of the experts, including Peter Summers, shows that the point isn't whether or not the voice recognition software is accurate. The point is that there's no way of telling whether the voice file be considered by that software is the right voice file. And if it was a right voice file, whether the wrong voice is on it because of cheating by the individual or cheating by the college, frankly, nobody knows. And I mean, it's a bit like, to me, the police being aware that drugs are being sold in a nightclub and therefore going in and arresting everybody they find in it. Now, the forthcoming second case of RK and DK may determine the issue of whether the Home Office evidence is even enough to raise a case to answer. I was desperate to be in that case. I've been trying to run that case for ages, and I really hope it goes well. The guys in it seem to have done a really good job. And then, of course, the last issue is what Theo's already spoken about, and to a certain extent, why many of us are here. The real issue is for a lot of people whose lives have already been destroyed by TOEIC allegations. It's all very well clearing your name, but clearing your name after 7 years, when your mental health is damaged, when you've lost all your fees, when you've lost effectively your 20s, because that's when people came. You know, what is good enough to resolve that? How can that be helped? And that's what we have to look at next. And that is all I was going to say. Obviously, I'm happy to try and help questions. It looks like there's quite a few.
Thank you very much, Greg. Okay, so we've got a few moments for questions. And we'll try and get through as many as we can. I'm just going to open up the questions boxes. Stephen's had to go because he's got another engagement, but please do stick around and we'll try and get through as many questions as we can. So and I should just say, if we aren't able to cover your question for time reasons, there is a Q&A section on the TOEIC Justice Project website, and we'll put in questions, obviously anonymizing them where appropriate, and answers. So let me see. So I withdrew my appeal in 2016. Very to dependent 14 since then. I'm not quite sure. What that means. Some of these are very, very specific to individuals. So let me look at the others. So the first one is, since 2005 to 2015, I was here legally as a student. I applied for indefinite leave to remain, but because of TOEIC, the Home Office dismissed my application. I went to court. I was refused at the end of 2018, applied for judicial review in 2019, and that was refused. And I applied under the Human Rights Act, and that application was rejected. And since, due to COVID and financial reasons, I didn't apply again. I've spent a lot of money on solicitors. What do I do now? Now my question is, what is the best application I could make? I had advice that I should apply FLR FP application. I'm confused and I don't know what to do. Have you got any comments on that one, Greg?
In terms of, I suppose, specific applications to make, in general, I think you're better off asking solicitors and barristers, because we tend to only see applications when they go wrong. But as a general rule, in the context of somebody who has been disbelieved at the tribunal, and I'm assuming the client, this individual, has been disbelieved because obviously I haven't seen the decisions, but you're going to have to challenge those decisions head on. And it doesn't matter which kind of application you make in terms of the form. You're going to have to meet the fresh claims test. So I've done a couple of these in terms of where people have had their appeals dismissed, sometimes all the way up to the higher courts. But it may well be that, for example, in some of the ones I've seen, the tribunal won't have been directed to that evidence that I talked about from Peter Sommer and from the other experts. It may be that the Home Office will have presented the evidence of Professor French as being 99% accurate. There are many. One of the really marked things in the TOEIC cases that I've seen is that a lot of the solicitors representing people have often not been aware of the really convoluted factual picture. Partly because the reported cases are kind of dense, and you have to actually read the underlying reports. So, I mean, the short answer is what you need to do is a fresh claim, a human rights fresh claim, paragraph 353 of the immigration rules. To a certain extent, it doesn't really matter which form you use, but I think a solicitor is probably better tasked to tell you which particular form. But certainly what you need to be doing is making a fresh human rights claim, fresh representations.
Thank you very much, Greg. So you've talked about the RK and DK case, which another person on the chat asks about. A third one says, I've lost in the first tier tribunal, have got permission to go to the upper tribunal, and I'm now waiting for a hearing. The court is waiting for the RK and DK case. So is it wise for me to make a compensation claim? Is it going to affect my case, as I'm still challenging my allegation of being a cheat on the TOEIC test? That's a very good question that lots of people ask when they contact us about compensation claims. Do you want to answer that one, Theo?
So broadly speaking, there is no interaction between your claiming compensation and your immigration case. So lots of people do claim compensation from the Home Office for different things, often, for example, for false imprisonment, while their immigration status is still unresolved. And that will not impact on the outcome of the immigration case. It's also important to remember that when you're in an appeal process, it's the tribunal that is going to make the decision in your case, not the Home Office. The Home Office has already decided that they don't want you to stay here, and claiming compensation from them is not going to make them like you any less. But the tribunal judge will have no knowledge of that claim, and it won't impact on their decision. I do really sympathise, though, having said that, with the position of people who are still waiting to resolve their immigration cases, and feeling that the stress and strain of getting involved with further legal proceedings when you're still trying to sort out this central issue is too much for you. Our advice is to issue as soon as possible to try and fit within those limitation dates that I talked about earlier. But that's a decision that each person needs to make for themselves about what you can do.
Sorry, could I just say something very briefly on what Theo said there? Sorry, John. I just wanted, I've been doing first year tribunal appeals since 2008, and I've never seen an appeal affected by the fact that somebody was bringing a civil action at the same time.
Yes, I mean, obviously, people. It's a natural concern to have. What you will find once you start going down the road of a compensation scheme is that it's a very long road, and the first few steps are to tell the Home Office that you're proposing to seek compensation from them. They won't reply to that letter most likely, certainly not anytime soon, and then the claim's issued to sort of protect your position and stop the clock running as far as the time limits are concerned. And then once that's happened, you have quite a lot of control, certainly in the early stages, which is where most of the claims are at the moment, over how quickly or slowly it moves, because you're the claimant and you're pushing that process forward or not. And so what people sometimes do is say to us, right, well, we want to protect our position on timing. Please make sure that we've got a claim issued, but don't take it forward to the next stage whilst we're sorting things out, either with the Home Office or dealing with other difficulties. But as Theo says, the general advice is, because litigation is always subject to time limits, and because the TOEIC problems have been going on for such a long time and the time limits have been running up in the meantime, it's always a good idea to take protective action in general. Okay. Somebody says, good afternoon all. Is it possible to help me to do the claim because I have left the country voluntarily? How can I hire a lawyer from outside the UK? Please let me know. Well, I'll try and answer that one. So it is possible to make a claim against the Home Office from abroad. That's no problem. Our legal process allows that. You don't need to instruct a lawyer abroad. You can instruct a UK-based lawyer here. And in fact, unless a lawyer abroad is also qualified to practice in this jurisdiction, that's what you'd have to do anyway. And you'll see on the TOEIC Justice Project website, there's a form for people to fill in if they're interested in us looking into their compensation cases and whether it might be appropriate to bring one. And do please complete that, and then we'll get in touch with you to take some details and see how we can help. And as Theo said earlier on, most of the help that we're giving people is legally aided, so funded by the government with sometimes a contribution. Next, dear panelists, my question is to Mr. Timms. Well, he's gone unfortunately, but how optimistic are you about Home Office policy changing anytime soon? How about Cameron answering that one?
Yeah, that's fine. As we know, Priti Patel is pretty hardline on immigration. If you look at what's come out today from the new Borders Bill, we can see that 10 times over. I think, though, with the pressure that's been put on over the past few years regarding TOEIC, we've put the Home Office in a difficult situation that they can't just ignore it anymore. And that's what they've been trying to do for a long time. A few years ago, as Stephen said earlier, there was a system almost ready to go that just had to be okayed by Theresa May at the time, just to solve everything. So they've got everything they need to get going. Will it happen if we carry on piling on this pressure and we continue to push and campaign? It can happen. It's going to be hard fought, but we can definitely do it. And it's just about, continuing to prove that this evidence is just completely unsatisfactory and not worthy to be in a court. but I think we can see a change of policy, but we're going to have to keep working on it for a long time. It's not just going to happen overnight.
Thank you very much. Well, I agree with that.
You've muted yourself, John.
So I have, yeah. Another questioner says, I lost my case 2 times, and the 3rd time I won my appeal. The Home Office challenged it in the upper tribunal, and it was sent back to the first tier tribunal. I contacted the ETS regarding my recording. They sent me somebody else's recording, and I asked them to send me my data, or the metadata file, and they said we can't. Is there anything else I can do? My hearing date's on the 23rd of July. I mean, I think obviously speak to the solicitor who's dealing with your individual case about that. In terms of access to the metadata, I mean, Julianne might have a view on that, but I would have thought that was, if you're identifiable from that data, then you have a right to access it under the GDPR and the Data Protection Act. Is that right, Julianne?
I mean, that should be right. Well, one I think is you should ask questions about what you can do to push for the disclosure for the proceedings, because I don't see on what basis it could be refused as irrelevant to the proceedings given the wider context. But second, in any event, in principle, if it's your metadata and it's linked to the file, you have a right of access to it, and they have to provide a lawful justification for not handing it over. So I think for those 2 reasons, I would speak to your lawyer who's got conduct of the tribunal hearing coming up and ask them really to push to get it, because it may well be that in fact they don't really have the metadata, and that's the actual answer, and that feeds into the concerns that Greg was raising, which is the sort of where we've kind of got to now, that they can't actually prove how they link any particular file with any individual, and that might really help your case if they actually have to confirm they don't actually have relevant metadata, or the metadata doesn't actually show the connection between your test and the file.
Okay, thank you very much, Julianne. So I'm just going to deal with a couple more questions given the time. So the next one is similar to one of the earlier questions. Somebody's got an outstanding appeal. Sorry, the Home Office has got an outstanding appeal on their status in the upper tribunal. They've succeeded earlier on. And they're asking, can they start fighting for compensation now, or do they need to wait for the Home Office decision? I think the answer to that, Theo, would be, the ultimate Home Office decision would be, well, yes, they could start the case now, but of course, in some instances, it's going to be easier to substantiate the compensation case once the immigration case is concluded. So that might be the kind of case where people issue protectively and stay, and then wait and have their immigration status sorted out.
Yeah, exactly. I think I still definitely suggest taking advice now and probably issuing your claim protectively, assuming that the initial Home Office action against you was 6 years ago, which is likely to have been in most cases. But yes, start now.
Okay. And then lastly, and we will try and answer the others through the Q&A on the TOEIC Justice website, but we just to stress, we won't name or include any identifying information about anybody on that Q&A. On compensation, what evidence can one gather to prove suffering, as most relied on support from family and friends, and so lack formal letters, etc. Greg, Theo, and Julianne, do you want to comment on that?
In terms of evidence to prove suffering, well, there's a number of different ways you do that. I mean, we would put in witness statements from family members and from friends, or from anyone to, and particularly from the person themselves, to show how they suffered. And you do need to really substantiate that in any kind of damages claim. But if you, for example, are somebody who suffered mental health problems, and there's a lot of people who will be in that position, that's the kind of thing that you might want to evidence with some kind of a medical report. That would be a thing that you could look at, but you need to be quite careful about that in terms of time limits for personal injury cases. But it isn't enough to just say that you suffered. You're going to have to make that case out, but you really can do that in terms of witness statements. You might think that it's difficult to do that, but really, you know, a well-written, detailed, comprehensive witness statement that sets out exactly what the effect on you was, maybe augmented with witness statements from family members or friends who can say how you were affected, I think can go a long way. And in a lot of cases, people will have had really serious financial problems, and that's the kind of thing that you can evidence with bank statements. You can evidence with, for example, if you ever had any contact with debt collection agencies. I know a lot of people really fell quite far into debt, but my experience is that most people who were victims of false TOEIC allegations really did suffer, and in most cases, I think it would actually be quite straightforward to prove.
Yeah, just to add to that, particularly on the distress of people often get concerned when they think about data protection that they've got to try and explain something technical as to why data protection claims kind of affected them. You really just have to explain your story of why the false allegations affected you. And so any judge is going to understand if it's, as Greg says, as an explained statement. One, you can explain just very in your own words how it feels to be accused of cheating as someone who has no history of any such allegations and no need to do it. And then you can explain impact on your family and friends and everything else. But also quite often it's effective in this area is to have sort of members of your family or friends or even former work colleagues who talk about just the change in you that they saw as a result of this impact. And often, you know, people have, in similar types of cases, I've seen really powerful witness statements that explain that once kind of these kind of false allegations have been made, the person's withdrawn from normal life, or they've lost contact with you because you've just become a different, you know, that you've become a different person. So there are lots of different ways of telling the stories, people who've lent you money or you know, everything else. So that can all really be done through evidence.
Absolutely. And it may be that down the line, you would need to speak to those witness statements in court, were the evidence disputed. I suspect that what will happen in these cases, and we don't know for sure, they're test cases, but I suspect what will happen in these cases is that of the number that we take, far smaller number will be sort of selected as test cases. The legal principles will be litigated to establish in principle that people are entitled to compensation on the bases that Theo and Julianne have talked about. And then it may be that there are some further test case hearings for the courts to decide how much damages ought to be paid in those test cases. And then those in turn will generate legal principles that are applied in the other cases. That's the sort of long way. The short way is that the Home Office may well negotiate on damages in individual cases or in groups of cases once the legal principles have been determined. And that's what happened, for instance, in the litigation about the Mau Mau camps and things. The Home Office fought a long, brutal war to try and establish that people who were rounded up and incarcerated in Kenya, accused of being terrorists and stuff, were not entitled to claim compensation at all. And then once those battles were all concluded and the in principle entitlement was established, there was then a mediation to decide how much people should get, and nobody ever actually had to give first-hand evidence in a court about their individual suffering. So there are shortcuts of a sort. Not they don't shorten the journey very much, but at the core of it all is a statement that the solicitor would be helping you with to tell your story to a judge whose job it is to read it and consider it and think about whether, having heard that story, the law should provide a remedy for what's happened, and we're hopeful that is what will ultimately happen for those who are in a position to take legal cases in that way. So I'm sorry about lacking the time to cover all the questions. We will, as I say, try and cover off the remaining ones in the Q&A. It only remains to me to say a massive thank you to everybody who's spoken. Stephen's not here, but thank you so much, Nazek and Cameron, Julianne and Greg and Theo, and thank you also to my colleagues at Bindmans who you can't actually see. They're the black boxes who really are the ones who've made all of this happen, both in terms of the seminar this afternoon, which has been fantastic, and the website, which is a really fantastic resource too. And I'd encourage everybody who's been watching to have a look at that. We'll send you a feedback form, as was mentioned at the start, and do fill that in as well. And if you're still caught up in the after effects of the TOEIC scandal, stay strong, and we will do what we can to support you. Thank you very much.